Yes, good evening to everybody, to this class, and this is the class for the JCJ, that is a Junior Civil Judge 2022, conducted by the state of Telangana for the main examination. And yesterday I made it very much clear that I am going to deal today the facts which need not be proved, that is the section 56 to 58. Participants, anyone can unmute and read what I posted on the screen so that you could know, I could know that you are with me and I am with you, both are traveling the same boat to reach to the destination. Hurry up. I say participants, anyone can unmute and read what I posted on the screen.
Facts which need not be proved, sir.
Keep your gadget very near. The sound is very much low.
Facts which need not be proved.
Only that much is there. Only that much is there.
Sir, Indian Evidence Act.
I wrote the good evening to the aspirants of the JCJ 2022 main examination, Indian Evidence Act, facts which need not be proved within parentheses, section 56 and 58. And later on, Professor Dr. Mohammed Saheb and Professor of Law, South Tanzania. These are the things are there. But anyway, it doesn't matter. Huh? Okay, now let us see the in nutshell that what we are going to do, the facts need not to be proved. And here I made it very much clear in the class also, I dealt it. These are some of the facts which even though relevant, they need not be proved. That means evidence need not to be given of such a facts usually because either the court knows about it or the opposite side had already admitted them. So it's a judicial recognition in one way. In the Evidence Act, these type of the facts are dealt in section 56 to 58 of the Indian Evidence Act 1872. And when you see the section 56, the Indian Evidence Act 1862 speaks about, I quote, facts judicially noticeable. Means it will notice that judicially noticeable need not to be proved, I unquote. According to this section, all such facts of which the court will take the judicial notice, when the court has taken the judicial notice and that facts need not to be proved, number one, other party admitted it and that facts need not to be proved. So judicial notice is a rule in the law of evidence. It is a rule in the law of evidence. It is not a substantial law. It's merely a rule. But we can say in other words is the procedure which allows the certain facts to be introduced in the courts as evidence if the truth of such facts are so well known are notorious that it cannot be reasonably doubted. And in such a thing would be there, are so well known, are not notorious that it cannot be reasonably doubted. So, one cannot be doubted over there where the court has noticed those facts, and such facts will need not to be proved. It is thus the tools which the judge can accept without having a party to prove it through evidence. This allows the court to fast forward the proceedings and letting the judge accept some notorious or well-known facts. See, when do you say notorious and when do you say famous? Participants, please throw the light on it.
Notorious means
Ask the question, participant, throw the light on it. Notorious and famous.
notorious means dangerous, sir.
Suresh Punam, keep your gadget very near so that the voice would be the high.
Sir, notorious means dangerous, sir. Dangerous.
Repeat.
इसमें आता है दो कटोरियां डालना आटे की ऊपर ऊपर से
Gagandeep, I asked the participants, you are the one of the hosts. You are notorious for a bad thing. For instance, if a thief is there, or a murderer is there, rapist is there, that fellow is a notorious person, we will say. Means a negative way he is a famous. And that's why we can say notorious. For the famous, for positive act, we will say the famous. Is it clear? We don't say famous criminal. What do you say?
Notorious criminal.
Notorious criminal we will say. So that is the wording that you use it.
Hardcore criminal also we say.
Yes, sir.
Hardcore criminal.
Yeah. Yeah, a heinous criminal, a person who did the heinous or dastardly act and traditional crimes who committed over there, we can say the notorious. So Section 57 of the Indian Evidence Act 1872 speaks about, I quote, facts which court must take judicial notice. I unquote. Section 57 lists out the 13 facts regarding which the court has to take the judicial notice. In those 13 items mentioned in the section item 1 to 3 comes under the topic of law and customs. Item number 4 to 7 comes under the topic of public administration. And item 8 to 13 comes under the head of the common knowledge. They say item. What is this item 4 to 7? Can you say subsection? Can you say clause? Anyone? Did you understand the question? Say yes or no. I say item 4 to 7 under the section 57. What is this item? Can you say it's a subsection or can you say clause? That's my question. Yes, we made it very much clear yesterday.
Clause.
See, I am showing here again. Okay, now it will come. 57. Did you see it, which I shared on the screen? Facts of which court must take judicial notice. The court shall take the judicial notice of the following facts. That means a tail is there, and afterwards colon and dash is there. Later on, one is there, and one clearly written in italics. So what do you say? Can you say subsection 1 or says a clause 1?
Clause 1.
It is a clause 1. So item there is, and Kolikonda Sharad Babu has read some of these clauses 1, 2, 3, 4, 5, 6, 7. But the explanation which I have given here, they made it in the form of item.
Okay.
So they say it's an item. Oh, this is a different one. Okay. So they say item 4 to 7. Let me come to the first point. There are total 13 items are there. Means 13 clauses are there mentioned in the section. That is clause 1 to 3 comes under the topic of law. That is about custom. And item that is a clause 4 to 7 comes under the topic of public administration. And clause 8 to 13 comes under the head of common knowledge. So it is provided that what is those cases explicitly mentioned in the section, the court has to take the judicial notice in the matter of the public history, literature, science and art. Kolikanda Sharad Babu has made it very much clear in the last class. The history items or literature items, science items or art items, court may resort for its aid to appropriate books or documents of reference if they quote it. And it will take the notice of it under the clauses. So, in that way, the real difficulty here is to distinguish between the facts. For example, if you are asked to distinguish between a book of history and a book referred for the purpose of the section 35 to 37, the real difference is that in case of matter judicially noticed, the court is merely refreshing its memory. The court actually knows about the fact, but still it refers to the book to refresh its memory, whereas in the case of a book tendered as evidence, the court does not know the facts or the information that is given by the book. So that is the distinction which is made, how a court will take the judicial notice of it. Suppose the court take the judicial notice of it, then why the court again wants the book? Yes, anyone?
Refreshing its
To
memory.
refreshing the memory, it is clearly mentioned. See, when you are giving it is 162 statement to refreshing the memory, and the statement will be given to the witness. Am I right? Venunath,
Yes.
because the case, he made the statement about the 6 months or 6 years back. He could not know what he said at the time. At the time, to refresh the memory, the written statement will be given to the witness for the refreshing the memory.
Yeah, it is like a case diary for the police officer.
Venunath, keep your gadget very close so that I could hear your voice very loudly.
It is like case diary for an investigating officer.
Okay. Now I would like to introduce our a new guest, and she is an assistant professor in the Petroleum University. Madam, tell me about your university and your name. Madam, are you there? Yes, I saw the Deepika. No, not Deepika. Mamta Kaur. Madam is not present. Just before she was there. Kaur. Madam, are you there?
Yeah, I'm there. We can see her name. Mamta Kaur is there. MK.
No, Mamta, this is not Mamta Kaur. She is a Gagandeep Kaur.
Okay, sorry. My mistake.
And she is an assistant professor in the University of Petroleum and Energy Studies, Dehradun, Mussoorie.
Matsuri. Yeah.
Just now she left, sir.
Just now she left. Okay. Because I thought when the people have gathered over there at the time, I would like to introduce her. That I told, and but anyway, that might be there. Okay. Meanwhile, I will call her, and then I will tell her, Madam, could you come once again? Yes, Sharath, can you read the case law?
Yes, sir. Omkar Nath and others versus the Delhi administration. In this case, the appellants were union leaders of the Northern Railwaymen's Union. They were accused of instigating other workmen towards striking and were booked under Rules 118 and 119 of Defense of India Rules 1971. They were sentenced with 6 months of rigorous imprisonment by the Metropolitan Magistrate of Delhi. The conviction order was upheld in a
Yes,
revision
madam,
appeal.
because I thought that because when the students joined more at the time that I would like to introduce you with that view only.
Additional Sessions Judge of the Delhi High Court. So actually, in defense, strikes are banned, I think, sir.
Could you come at least for 1 minute now? Could you come at least for 1 or 2 minutes now?
Yes, sir, sure.
Yes, please come. I heard your name, but I did not see you. Okay, next. Okay.
Hello.
Yeah. So, yeah, I asked the madam to join it now. Okay. So this case law, what it shows, can you tell the
So,
In defense rules of 118 and 119,
okay.
strikes are banned, and so the union leaders were booked and given imprisonment for 6 months.
sir, as per the, can I say something? Hello.
Yes, please.
As per the industrial dispute or as per any labor laws,
Okay.
no army officers, army institutions, navy, air force, policemen, they don't come under the definition of union or worker.
Okay.
They report, the central forces report direct to the president.
Yeah, now I admitted Gagandeep Kaur, and welcome, madam. And I would like to share her. Yes, these are the things, Deepika Gagan Kaur, that do small things with great. It is put it over there on her desk. I mean, at the background. And the life moves pretty fast. If you don't stop and look around, once in a while you might miss it. It's a very beautiful quotation. Then we can find nothing great was ever achieved without enthusiasm. So it is also one of the a great motivational quotation. She put it over in her office. If you want to be happy, be what?
Be happy.
Be happy. Yes, it is the madam image, and you could see at the back on her office those quotations are there. Madam, you can speak now.
Sir, this is my pleasure that you have invited me for your class, sir. And it's a great honor for me. And thank you so much for this. And I want to give my best wishes to the students. They are very lucky as they got a wonderful opportunity to learn from you, sir. I personally have high regards and a huge respect for you. The work you are doing is really commendable, sir.
And
So
madam is a very good moderator, because I will show you here. She is a moderator at the time, and she is using the English very articulated manner. And this is, of course, she also sent this to me. But actually, that I participated in this international webinar, and that is about John Lang, because I did not know that it is John Lang who defended the Jhansi of Rani.
yes, because very few information is available about him, Mr. John Lang. I hope your students, if they have learned the history, Indian legal history, they must have heard his name. That is John Lang. Have you heard any one of you
Participants, give the
participants?
answer, keeping your palm on your heart. Say truth.
You can
No,
say
sir.
yes
No,
or
no,
no.
no, no, no.
Sir.
No, you see, this person is a forgotten
Might
hero.
I want to raise a doubt, madam.
Sir.
She, as the Rani of Jhansi, was not captured. Did the trial against run?
No. Basically, what happened that at that time, when there were so many, we can say we were slaves at that time, and this person, he was Australian barrister. He came to India and he represented India against British Empire. It was not that she was into a litigation or there was some litigation against her. It was not like that. He seconded the point in the favor of India. Being a barrister from Australia, he took a stand against British Empire, and his grave is in Missouri. So at that time, you can Google about him. So so.
But how that is relates to Jhansi Lakshmi Bai? If he has fought for
Mhm.
Indians, how that is related to Jhansi Lakshmi Bai? It's no related to Jhansi Lakshmi Bai.
See, at that time, there was some issue related to the property, and he represented that issue in the favor of Jhansi Ki Rani against the British Empire. Basically, I'm not
So
from
basically,
legal.
what you mean to say is he argued on behalf of Jhansi Lakshmi Bai in the British court.
Yes,
So that is not
and
a great thing. Anyone can do
yes,
that.
Yes,
yes.
Venu, not only that case, he's argued some other case also. If you Google
Okay.
it, you will know that how many cases he
Yes,
argued
yes. We'll do
against the
that. I'll do that.
Britishers.
I'll do that. I'll do that. I'll do that.
At
I'll do
that
that.
time, just think that, just take the example in that context. At that time, when we were slaves and nobody was having any courage to speak against that British Empire. So that's in that context that this person contributed a lot.
And the Techno Edge World LLP, are you a founder member of that, madam?
So basically, there is my one student. He has come up with this LLP, Techno Edge. As such, I am advisory to this. He wanted to be, an active founder. However, due to my hectic job schedule, you are aware in private universities, we are all stuck all the time. So I'm simply guiding him, like
Okay.
how he can proceed with his this new startup.
Okay, madam. Okay, thank you very much for your appearance
Thank you so much.
in our online class. And Professor Dikshit is also a very good friend of mine. It is he who recommended. Professor Dr. Anil K. Dikshit, and he is a professor in the Uttaranchal University.
So, my dear students, and all the very best wishes. You are lucky to have sir, and his way of teaching is wonderful. I would say best wishes. I want to see you all as judge.
Thank
Okay,
you.
thank you very much, madam. Okay, let's back
Thank you,
to
sir.
yes.
Thank
Let's back to Kolikonda. So, Venunath, you understood that Rule 118 and Rule 119 of the Defense of Indian Rules. There they say a special privilege will be given to them. Is it?
Yeah, I didn't get. Now, what you're saying?
A special privilege will be given to the defense people.
Yes, but for what special privileges?
They need not to come and give the evidence, and the court will take the judicial notice of it.
Yes. That's there.
Okay, another case law is that S. Nagarajan versus Vasant Kumar and another. Here in this case, the respondents were husband and wife by relation and had two shops located in Trivandrum.
Yes,
Where is the Trivandrum, participants?
It's in
Not
Kerala.
Raghunath.
Kerala.
Is Kerala's capital.
Tiruvananthapuram.
Now it is Thiruvananthapuram, but earlier it was Trivandrum.
What is the beach, famous beach?
I don't know about the famous beach, but I know
Is
Lord
it
Padmanabhan
Kovalam
temple
Beach?
is there.
Kovalam Beach.
But I know one thing is Lord Padmanabhan temple is there.
Yes. So in this case, their residents were also located in the vicinity of those shops. So what happened? The petitioners, that is the officers of the customs, preventive and intelligence unit, and obtained the information the foreign goods were being sold in those shops and also stored in the houses of the respondents, searched the shops and also the house premises and seized them. That means some of the they confiscated some of the goods which are sold without the permission. I think those are the foreign goods. A trial was held under the Customs Act 1962 with the prosecution asserting that the respondents were guilty of the committing an offense under the section 135 and class 1 of the said act. I don't know whether the class 1 subsection. If it is a act of the customs, then we can know it. So let us, for timing 135, one of the said act. So however, the respondents contended that the seized and confiscated goods were not for the sale, and also the notification by the central government are not loss of the consideration under section 57 plus 1 of the Indian Evidence Act 1872, thereby pleading not guilty. So what happened? The trial court maintained the contention and order in favor of the respondents, to which the petitioner appealed before the High Court of the Kerala. The High Court of Kerala, after making the due observations and consideration, overruled the trial court's decision and held that central government notification are indeed laws within the ambit of the section 57 class 1, and therefore respondents were held guilty. So if you merely keep such a foreign goods in your shop, either for the shop windows, like we have one case law, it is only the invitation to sell but not for the sale.
Sale.
What is that case law? Flick knife case law I discussed in the contract.
Yeah.
What is the name of the case law? Fisher versus Bell. The name of the case law is?
Fisher versus Bell.
There, the flick knife is kept over there. According to the Weapons Act of the Lennon, you are not supposed to keep it. But he said, it is only invitation to sell, but it is not a sale. But here, The trial court gave the same thing. It is not a sale, only they kept it. But the High Court of the Kerala said, merely keeping in the shop such a foreign goods, automatically Section 57 Class 1 is applicable over there. That means,
The same way Sanjay Dutt case.
yes, same. Please, could you enlighten?
Yeah, it was during Bombay riots, Bombay blast, when Sanjay Dutt kept one AK-47 rifle in his residence.
Yes,
That was only for his protection, what he stated, but
Yes.
actually he didn't use it anywhere.
yeah.
He was held under Arms Act
When you want to protect, you should have the license.
license.
And that to be, can a person will be given the license for AK-47? I doubt.
Only for pistol will be given.
Only revolver, of course, 12.8. Of course, there is a gauge is there, the bullet gauge.
Either for
Up to that
revolver or
extent
for
they will
pistol
give.
will be given.
12
Either for
rounds.
revolver-
12 rounds can be given.
Yeah, revolver has 6 rounds. Pistol has 12 rounds.
Okay, 12 rounds. Because I saw the 12 rounds pistol handling. It's a very weight.
It has magazine. It's called magazine.
But down, he showed me that how to load it.
Yes.
So, a license should be needed over there. Hence, the High Court, they said, we will say the judicial notice there. Yes, it is. For the same, you can make it out that you are going to sell it. Hence, they will be held liable to keep such thing which are foreign goods where they did not have the license to it. So, this is the thing which you want to make it out. And now the time is 8:29. Of course, can I shift over to the Kolikonda? Sharad Babu, now your turn is there. So I will show you your, yes, where it is gone. Okay. This is the thing. I already put it on the screen. Not, this is not yours. Oh, it is here. Okay. Yes, now go ahead.
So the topic is limitation bars the remedy and not the right. Actually, right is primary, sir, and it is a substantive right. But the remedy is secondary right according to this limitation bars the remedy and not the right. In this
Is it
statement,
given in the section 3 of the Act?
yes, the word right is used to mean a primary and substantive right. In the wider sense of the word, remedy is also a right, but a secondary right, a procedural right. The rule that limitation bars the remedy but not the right is contained in Section 2 of the Limitation Act.
Section 3 of the Act.
Okay. What about the section 27 says?
It is an exception, sir, for property.
Could you deal one case law? I will show you the case law.
That PNB,
Yeah.
PNB versus Surendra Prasad
in
Sinha.
case PNB versus Surendra Prasad Sinha, year 1992, Supreme Court, PNB gave loan to Mr. Dubey. Surendra Prasad Sinha stood guarantor and executed a secondary bond giving FDR to bank. So loan was given to Dubey, sir, and Surendra Prasad Sinha was the guarantor.
First, ask the participant, what is PNB?
Punjab National Bank.
Yes, sir.
Yeah, sir. इतना भी छोटा चीज.
I want to get answer from other people, not you.
Count
Okay.
Dubey defaulted in payment of loans,
Okay.
and the limitation period was also over, and the bank could not collect the money from Dubey.
Okay.
However, Surendra Prasad Sinha's FDR was with the banks,
Okay.
and from that FDR it recovered money which is due from Dubey because he was the guarantor. Surendra Prasad Sinha was the guarantor.
Okay.
Later, Surendra Prasad Sinha complained, sir. He lodged a criminal complaint for 405 and 409 criminal misappropriation.
Then misappropriate the court. I mean, bank misappropriated that one.
Yes, Yes, against bank only he lodged it, that it misappropriated his FDR
Okay.
because it deducted the amount from FDR,
Okay.
the amount that is due from Dubai and credited. So
What the court had dealt?
the HC declined to quash complaint, but SC quashed the complaint.
Okay.
SC said, though the right to enforce the debt by judicial process is barred,
Mm-hmm.
right to debt remains.
remains.
So the right to debt remains.
Okay.
If the amount is there, it can deduct. The bank it can deduct, though the limitation time is over.
Okay.
Barred by the limitation.
That
The
means
time-barred debt does not cease to exist by virtue of Section 3. The debt is not extinguished, but the remedy to enforce the debt is destroyed.
that
That is
means
the
the
case
court
of-
is having the right to deduct from the FDR.
Yes, the bank has the right and the Supreme Court held it.
Even though it's a time barred.
Yes.
Yeah, recovery of money is for 3 years.
Likewise, sir, in case of promissory note also,
Okay.
if the debtor gives money for a few accounts, if
Okay.
some of the accounts are time barred,
Mm-hmm.
it is the discretion of the creditor to credit the amount in any one of the amounts, credit
Okay.
any one of the credited amounts, even though the time is barred. He can credit it to any promissory note.
Okay. Okay. Or can you make it the Balakrishnan?
Yes, sir. It is the same case, I think. In Balakrishnan versus M.A. Krishnamurthy, 1998, 7 SCC 123, it was held by the Supreme Court that the Limitation Act is based upon public policy, which is used for fixing a lifespan of a legal remedy for the purpose of general welfare.
Okay.
It has been pointed out that the law of limitation are not only meant to destroy the rights of the parties, but are meant to look to the parties who do not resort to the tactics, but in general to seek remedy. It fixes the lifespan for legal injuries suffered by the aggrieved person. Actually, if there is no limitation bar, sir, the cases will mount.
Okay.
The number of litigations will mount. That is the concept for putting this law of limitation, I think.
Uh-huh. What is
It has
there?
been
Say
enshrined.
maximum. They mentioned the maximum.
Maximum also is there. Interest, Republicat, sic finis litium, which means the law of limitation is for general welfare and that the period is to be put into litigation and not meant to destroy the right of the person or parties who are seeking remedy. The idea with regards to this is that every legal remedy must be alive for a legislatively fixed period of time.
In the sense, sometimes the court will condone the delay of the.
Yes, that is there, sir.
Okay.
But one thing,
Yeah, please.
if there is a limitation, if there is limitation in any statute,
Okay.
then this limitation of law of limitation does not apply to that statute. Example, in Negotiable Instrument Act under 138,
Yeah.
if a person does not file a case within that prescribed period of time, he
Mhm.
cannot go under Section 5 Limitation Act.
Mhm.
He has to go under Section 142 of the NI Act only, because there is a prescribed act limitation is there in that act.
Okay. Okay.
Whenever the statute says that there is a limitation for that statute in that same statute, then you cannot go to the Limitation Act. You have to follow the same limitation.
Which is stated in the NI Act.
Yeah, any act.
Any act. Any act. Okay.
Yeah.
Means when the any act it is clearly mentioned in the statute, at the time we don't go for the law of limitation.
Yes, and law of limitation is most of the people I see under 138 of limitation, they go under Section 5, or whenever there's delay in filing any case, they go under Section 5 of Limitation Act. But Section 5 of Limitation Act is different completely. That is for making of applications, not for suits.
Can the limitation will work in the criminal cases?
Yes, but not this limitation. There's a you have to go by CRPC.
Okay.
No, I don't think there is a limitation for.
Yeah, there is
criminal.
no limitation as per
There's
my
no
knowledge.
limitation. You have to go by CRPC.
Till one's life is there, he can be booked.
See, earlier in the Motor Vehicle Act, there was a limitation.
It was there for 3 years. Now it is 6 months.
But now they say, no, at any time he can file it.
No. As per the new Motor Vehicle Act, it is 6 months. Earlier it was 3 years.
But I came to know that the limitation period is removed.
No. You refer a new Motor Vehicle Act. A lot of changes have been done.
You're filing a case?
Yes. 6 months is there.
Mhm.
I'll forward you the judgment. Kerala High Court.
Okay, and yesterday that you cited the thing, no? Could you explain it?
Which one?
You have given the link yesterday, but I called you. You are not present yesterday.
Yesterday I was in a party, sir. I could not come.
Okay, but you have to ask our excuse because I told you that today that he is going to make it out.
Oh, sorry. I apologize.
Yeah, that is about the harassment. What is that link that you said?
That case is whenever the two dying declarations, which one should be treated as, which one the court should accept?
Okay.
First one or the second one?
Okay.
In that case, the person who dies, that's regarding the dowry case.
Mm-hmm.
In her first dying declarations, she says that she drank the medicine
Mm-hmm.
and she died, but it turned out to be a poison, thinking it to be a medicine.
Okay.
And mother-in-laws, sister-in-laws, whoever, they're not responsible for that.
Mm-hmm.
And in the second dying declaration, she made everyone party. Because of all these people, I was forced to consume this.
Okay. Mm-hmm.
So relying on both those two, honorable
Transactions.
yeah, based on these two, the Honorable Supreme Court said the trustworthy is the first one, not the
First
second
one. Okay.
Yeah.
They came to the conclusion with the corroborative evidence
Yes.
and prosecution independent evidence.
Yes.
So the first one is a genuine one. There is a veracity is there.
Yes.
And there is no ambiguity.
It is said whenever a person is about to die, he'll tell the truth. But if he gets a chance, then he'll make a lot of other things also.
Sharad Babu, can we read the critical note?
Yes, sir. It is sometimes expressed that the plea of limitation is dishonest plea. Although a debt may be irrecoverable in court, it nevertheless continues to be binding on the debtor in foro conscientiate, that is form of conscience. So it is in the consciousness, I think. This is the mind,
Sense.
in the area of mind.
Yeah.
But considering the object of law of doctrine of limitation, it cannot be said that it is unjust to raise the plea. Moreover, in India, the question of morality of the plea is of less consequence, or whether the defendant takes up the plea of limitation or not. The court is bound under Section 3 of Limitation Act to dismiss a suit if out of time.
Okay.
It is sometimes said that the statute of limitation is a statute of repose, peace, and justice. This is because the statute of limitation, in a way, furnishes guarantee to the general public that after the lapse of certain period, their settled rights or titles shall not be litigated upon in courts, and they may live in peace.
Yeah, but I saw there are one case is there which is an exception to the law of limitation.
Okay.
Can you tell anybody can tell that is a very famous case? It is an exception to the limitation.
No idea.
So, for possession of property,
See, I will come to the fact. See, this is also mine. Facts need not be proved. And this is, yeah. Let me come to the point here. We'll get it. It is given flat same to the broad. No, the limitation, no, that is. Limitation comes. Limitation. If you happen to see Mick Kesla, what is Mick Kesla?
Methyl isocyanate, Bhopal's gas tragedy.
Bhopal gas tragedy Kesla, and they made law of limitation will not work over there because the Union of India has made one passed an act on behalf of all the victim. They filed a case in the USA first, but the USA court made the scene. The forum shopping is in India. The reason is the cause of action held in India. Let the case will be filed in India. Again, on behalf of all the people, the Union of India filed a case against
Union Carbide.
Union Carbide.
Union Carbide. That is the case law. And
That
where,
Anderson was the managing director.
yeah, and they said law of limitation is an exception to this case law because it is happened in the year
1984
84. Is it 84 or 1994?
or 85, sir.
No, 84 only. So they made an exception. Law of limitation will not work in the Unit of India versus Union Carbide case law. Of course, he has given 1 or 2 or 3 point wise, but I kept it here on the facts which need not to be proved.
2nd December 1984.
Yeah, 2nd and 3rd.
Yeah, at night, midnight.
That is the midnight.
When the Bhopalis were
I don't know how many people went to the Bhopal, but once I went to give the interview in the National Law University is there.
National Judiciary.
There, I went over there, then I saw physically, still the people are surrounding, they are staying in the tents and they are living. And the company, everything is collapsed, nothing is there, it became a scrap. And no production, no nothing, and is deserted. And I saw the victims also, those who became handicapped because of this gas. And it is resolved on the out-of-court settlement, but the government, to my knowledge, did not give it, but only the interest they are paying to the victim. But the actual amount would be there on their name in the court, in the bank. And what I heard from the people, those who are the victims, I asked them, did you receive the total amount? They said no. Then what you are getting? Yes, total amount is deposited in the bank. The share.
even that is also I am not sure, sir.
No. They are getting the interest of it.
If they have received the total amount, it could have easily be distributed.
Yeah, but of course, depending upon the nature of the deformity. And that amount will be fixed. They are getting only that amount interest every month. But the amount is still fixed over there. Because I met one of the victim, and she could not walk. And she crawls. So that was the thing which I noticed in the Bhopal gas tragedy case law.
I remember reading one thing also, sir.
Yes.
Actually, people who tried to escape from the tragedy, who ran,
Yeah.
they died immediately because they breathed and
They breathed more, no?
More.
Those who are in the houses, are in the trap, are in the trench, they a bit survived, but with some deformity would be there. and I saw the pregnant woman, and they have given a premature birth, and sometimes with the clubbed feet, deformity will be found in the delivery. So these are the things which come across when you want to say, and you have given the case, it is here, I believe. I put it somewhere. I did not know because I want to delete, so I kept it Bhopal gas tragedy case law, and it is an exception to the rule of law of limitation. While we are making
Even tomorrow also we can.
Yeah. From the
Yeah.
Bhopal gas tragedy only, this absolute liability arose.
Yeah, that is the concept of the strict liability is changed to the absolute liability.
Yes.
Because everybody is taking the advantage of the 5 exceptions which is
Yes.
put it over there in the strict liability.
Yes, yes, yes.
And they are taking the 5 exception. Can anybody will tell what are the 5 exceptions? 5 exceptions.
One exception I know, that act of God.
Even a plaintiff, a wrongdoer also there. The stranger also there.
There. Fetcher versus Fetcher case, if I'm not mistaken.
See, rules of strict liability and its exception.
Fletcher was
No, that is one way we can say if any hazardous thing you maintain over there, if it is escape should be there at that instance, and a person who did it, kept it, and he would be strictly liable. So that is, and I'm showing here the exception because I already told. See, did you see it, the exception which I put it on there? Exception to the rule of strict liability, as a time has passed by the rule declared in 1868 has been many changes as reprieves. Here some of them, the exception, the rule of the land versus flag. Number 1, plaintiff's own fault. And the case law is given Ponting versus Knox. It is an excellent case law. And where the horse nibbles, protruded, went over there and eats, by that time it is died, then the plaintiff's own fault would be there here. Then the act of God is, that is called vis major. What is the civil law terminology for the vis major? Participants. I don't know why the other parties are very, very much dumb. KKN.
the actress.
What is the civil law terminology for the vis major? Vis major is the common law terminology.
One word I remember, actress.
No. KKN, are you present? Unmute. Sir, I don't know, say. KKN, are you hearing me? KKN is very silent. Gausia,
Natural calamities, sir.
those are natural catastrophe, natural calamity, disasters. I say, what is the civil law terminology for the vis major, act of God? Force majeure.
Yeah.
It is the French word.
Even at the time of pandemic also, Nirmala Sitharaman defended herself when GST was not distributed among the states.
Yeah.
The
Of
pandemic
course,
is
the act
an
of
act
God,
of
the
God.
famous case law, we know the Nichols versus Marsland, and everything is inundated in the, and later we can see that consent of the plaintiff, warranty not fit injury also comes an exception, and the 4th one is the act of a third party, and the 5th exception is statutory authority. In the statutory authority, we have the cases. One will not come under the statutory authority. Can I give the name of the case law? Can I say the facts of the case law?
Reliant versus Fetcher?
That is the strict liability case law. I am stating about statutory authority. One cannot file a case.
It's a railway case.
It's the railway case law. Anyone, The railway department never allow the green grass to grow between the rails.
Between the tracks.
Why? Why they will not allow the green grass to grow? Because the grass is there, which is stops the erosion.
Hmm.
If you don't know, say pass on. I will give you the answer.
I don't know, sir.
The stones will be disturbed.
They kept the stones. I know that the stones are kept over there to support the sleepers to get inside, so that it will not be lowered down. So they will make it a packing in the down at the foundation. If the green grass will be grown between the rails,
There will be no movement of stones.
at the time, quadruped buffaloes or the cows or bulls, they don't have the hypothalamus, the reasoning power, they will come and eat. Even though there is a whistle sound also, they don't go out. And that is the
Them on
reason.
the roads also.
But
That is
railway,
that is the reason they don't allow the grass to grow between the rails. They will make it clean, and the time they remove the grass and they left the grass adjacent to the line, the grass, green grass, become the hay after the 3 days, and the chimney, the live coal come out of the chimney, falls on the hay, and the hay got ignited, and there was a wind, it will be carried away and burn the plaintiff's hay stalk. And plaintiff bring an action against the railway company. Railway company has taken the defense. It is the statutory authority to run the railway. But the court has given, it is no doubt it is a statutory authority to run the railway, but leaving the grass negligently adjacent to the line when it becomes the hay, and it is a negligence on the part of the railway to not to remove such a thing, and hence the railway is held liable to pay the compensation. That is the case law. London South Western Railway Company. I think it is a Lloyd versus, if I not be mistaken. So that is the case law with the negligence on the part of it, hence statutory authority defense one cannot be taken. That is the case law. Yes, participants, any doubts? It is an ocean. We are only touching some of the points where we want to make it out. And the tomorrow class, I would like to deal the IPC, any one of the point, question, or you can post it so that we can deal it. Are you hearing the participants?
yes,
Say
yes,
yes.
Yes, sir.
yes.
Yes, sir.
Only Mamata Kaur is giving the answer, Gausia is giving the answer. But other people, I asked the KKN. Sir, I kept it open that I went for the sleep.
Also, they
Nagarav.
are serious.
He is alive, he's alive.
Seriously
He's
preparing
awake,
for
he's
the
awake. He's
exam.
awake, he's awake.
Nagarav, are you present?
Present, sir.
Nagarav, tell me what topic I should have to deal tomorrow in the penal code.
Difference between culpable homicide and murder.
Whether culpable homicide amount to the murder or that we want to say section 300 and 304 and 307.
304.
That's
Yes.
that's a small.
We will see which is a murder and which is a culpable homicide. Tomorrow I will deal it. Okay, Sharat Kumar.
We can talk
Babu.
about the truth. We can talk about rape, the recent amendment in 2013, what they have made in detail.
Sir, RPD also, sir, right of private defense.
Okay, but only one I can deal it because in the 50 minutes we will share the two. Sharat Babu, can you deal that?
I will deal with the right of defense, sir.
Okay, right of the private defense.
Yeah.
Okay, you deal the right of the private defense, I deal the culpable homicide not amount to murder and the homicide. And I don't know because the time is actually up because it is 8:57.
Sometimes it is very kind and
Of
sometimes.
course, the 857 means he is very kind enough today. And that's why that he is not making out. But still there is something, the facts which are to be proved or facts which are not to be proved.
They are also.
Anyway, that I will stop the today's class. KKN, I would like to hear the KKN voice. KKN voice, I could not hear it. SM Imran, are you present?
Yes, sir. Present, sir.
Very good. Where you did your LLB?
Kadapa, sir. Yogi Vemana University.
Okay, okay. Kadapa, they will make always the webinars.
Yes, sir.
Penchalaya.
Yes, sir.
Yeah. And very good. Can you tell me what is the LLB full form? It's not only to the SM Imran, it is all the participants except the host and Venunath.
Legum.
Yeah, correct. Go ahead.
Yeah, you're right. Legum, 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 Baccalaureus, BA, So that is because if you study the LLB and if you don't know the LLB full form, naturally people will not blame you. People will blame your teacher. Am I right?
Sir, I have
What
some
is
doubts.
Yes, please.
Legum baccalaureus, sir?
I will not ask I'll ask only the students.
Okay, so ask the student.
Okay, I don't know how many of you all must have read CRPC thoroughly.
But anyway, it doesn't matter you ask because it's the enlightenment to us.
What do you mean by submit in CRP? There's something called submit, committal, makeover, withdraw.
Still 5 minutes are there. Yes, anyone can give the answer from the participant side. I submit to the honorable court will say.
Each word gives different meaning, sir. All words are not give equal meaning. Each word is different.
No. I'm not asking the meaning. What do you mean by submit, committal, submission, makeover, withdraw? These are the terminologies every lawyer should know while arguing a criminal case in court. If he doesn't know, then I don't think he's supposed to be called as an advocate or a lawyer.
Withdraw means withdrawing a case because they are not contesting, they will withdraw the case if a party is compromised.
No, that is
And
not the correct
committal
answer.
is,
That is not the correct answer.
okay, clarify me if what is correct.
Submit means when a judicial magistrate transfer the case to the chief judicial magistrate, it is called submit. Understood?
Okay.
From lower court to higher court, when a case is transferred, it is called as submit. It is not called transfer. Never it is called transfer.
Okay, next.
Next, committal. The committal is what? The same thing, a judicial magistrate transfer the case to a sessions court or a judicial magistrate, chief judicial magistrate. Now, wherever there is a sessions court, you don't find chief judicial magistrate court. Either you have sessions court or you have CJM. Submit is exclusively from a judicial magistrate to the CJM. But in case of committal, it is from judicial magistrate to a CJM or to the court of sessions.
Can you say it is, why do you say it is a committal?
Committal, you are the word what they give is that you are not transferring the case.
Okay,
you are using
okay.
a legal terminology, which is saying that you are committing, you are withdrawing yourself and you're committing to someone else.
Okay, next.
Take over the matter.
The time is going to up now.
Yeah, and makeover. A makeover or transfer. These are referred in section 192 of this thing, from where a CGM is chief judicial magistrate, tells the judicial magistrate to take over the case from a higher court to a lower court. That is called makeover or transfer.
Okay.
Earlier it was committal and submission from lower court to higher court. No, higher court means not high court. I'm not talking about high court. Okay, and makeover or transfer is from a chief judicial magistrate or a sessions court to a judicial magistrate to a lower court. It is called makeover or transfer. Now the word withdraw. Now the word withdraw means the High Court orders the subordinate court to withdraw itself from that matter so that the High Court can take over that matter. That is called withdraw.
Thank you, sir.
Yes, I appreciate that. Not only that, we only the host, but from the student side also we will get some clarification to us, because I told you that it's a learning process, and sometimes we learn from you, and sometimes you learn.
Because everything, whatever I learned from you, sir.
Oh, I appreciate, because yes, Venunajis was my student when I was the principal in Akhila Bharati College of Law.
Yeah, he grilled us like anything.
Sir, one question is this.
Yes, please. Now time is up. Only 1 minute.
Under what circumstances a magistrate will submit the case to higher court?
Under what circumstances? Let's presume a judicial magistrate takes up any criminal case. He knows that punishment, if it is a judicial magistrate, has a capacity of giving only 3 years punishment. Let's say.
Okay.
But after looking into the case, after going into all the evidence, he finds that this punishment should exceed more than 3 years. But the jurisdiction of
He is
the
not
judicial
competent
magistrate is
to
only
give
for 3
punishment.
years. Then what he does,
Okay.
he submits to the chief judicial magistrate, where the punishment can be given higher.
Is it clear?
Yes, sir.
Yeah, at any time it can stop it. Meanwhile, any other question?
What do you mean by garnish?
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Jai Hind.